portraying there is that a decree may be passed in favor of the plaintiff pursuant of registered sale deed, and possession of the plaintiff may be confirmed, and if the plaintiff is not found possession, may be declared through the a decree for recovery of possession may be passed. The case of the plaintiff is that the landlord lordship transfer the land to the father of the plaintiff on 31st May 1940 by virtue of registered sale deed, and the plaintiff got his name mutated. The case of the defendant is that in the year 1941, the landlord lordship settled the land by virtue of hukumnama lordship. The learned first appellate court lordship dismissed the appeal only on the ground that state of Jharkhand is a necessary party because my Jamabandi was cancelled lordship. Lordship, may kindly see the order, the judgment passed by the learned first appellate court lordship. Para 9 lords. Para 9. The learned counsel for the appellant has framed his appeal stating provision of section 4 of the Land Reform Act, but it appears that the state has cancelled the Jamabandi of the appellant under the provision of CNT Act. In this circumstance, considering the fact discussed above, it appears that the suit suffers from an enjoinder of necessary party. My submission is that no relief was claimed against the state of Jharkhand lordship. May kindly see order 1 rule 3 CPC lordship.
Why was the Jamabandi cancelled?
Suspicious Jamabandi proceeding was initiated, and thereafter after lordship the my Jamabandi was cancelled lordship.
It was opened in somebody else's paper.
No. I'm sorry, lordship.
It was opened in the name of somebody else after cancellation.
No. The trial court held that the plaintiff as well as defendant have failed to prove his title lordship. But the no relief was claimed against the state of Jharkhand. Therefore, the state of Jharkhand is not necessary party according to order 1 rule 3 CPC lordship.
So, what is your substantial question?
A lordship, whether the learned court of appeal has misconstrued the provision contained in order 1 rule 9 CPC while dismissing the source on erroneous consideration. And B also lordship.
The trial court also dismissed the case on.
No. Trial court held that it is a their majorua malik land, therefore plaintiff and defendant have not able to prove their title lordship.
The other issues were not decided by the learned first.
Issue decided lordship, may kindly see the para 13 lordship issue framed by the learned trial court lordship.
Para 8.
Para 13 lordship.
Para 8. The learned court below discuss issue number 6, 9 and 8.
Yeah,
So these issues are discussed at first.
Learned trial court judgment lordship. Para 13 lordship. Page internal page 7 lordship. Is the suit barred under the principle of Chhotnaku Tenancy Act? Are the plaintiff valid procedure of suit property and are in possession? Is the suit barred for non-joinder of misjoinder of necessary party? Issue number 6, 7 and 8 decided in para 39 laws.
Non-joinder, with regard to non-joinder, what was the finding of the learned trial court?
There is, according to us, there is no findings, Lord. May kindly see para 39, Lord. Whatever the question that plaintiff has valid procedure or not, so in this regard, the plaintiff has produced their sale deed, which has been executed by so and so in favor of their ancestor. But from the periodical exhibit A, on behalf of the defendant, which is certified copy order passed in miscellaneous case number reveals that defendant of 5 in the capacity of village head along with the villager had filed a complaint before the deputy commissioner on so and so in this regard. Report called forth from the circle officer, and after inquiry, the circle officer submitted a report that there is a burning hut and tank upon the disputed land which is being used by the villager, and the Jamabandi in the name of S.K. Siddiqui and others are suspicious, and circle officer requested to cancel the Jamabandi. It is also, while it is say that it is also reported that khata number so and so land is as per the Khatiyan Gair Majura Malik land and registered to there is no any ground is mentioned regarding the Jamabandi, and the aforesaid Jamabandi is doubtful, illegal and plaintiff are not in possession regarding the disputed land. I would like to mention again that from the perusal of the Khatiyan it is also apparent that this is the land recorded there Majura Malik Parthi Khadi in Khatiyani also reveals from the perusal of the order of the additional collector that he has written in his order that Jamabandi Rayat have not been produced any document before the land reform deputy collector regarding permission for transfer of land. And Jamabandi is suspicious, and additional collector made a request to cancel the Jamabandi. Plaintiff witness number 3 has also stated the rent receipt was issued in the name of his mother till 2003-2004. But there is a division bench judgment Lordship Tarun Kumar Datta Lordship. There is no provision in the state of Jharkhand for cancellation of Jamabandi Lordship. The long-standing Jamabandi cannot be cancelled.
What is the oldest rent receipt you have produced?
The last rent receipt is 2003
Oldest.
2003 to 2004.
Oldest.
Lordship, I am not able to oldest rent, so my oldest rent receipt is concerned. Lordship.
Who executed the sale deed in your favor?
Deed and landlord not to juggle.
And the defendants are claiming to be the descendants of the Khatiyani.
Yes, no, he is claiming on the basis of Hukumnama.
By the same landlord.
Yes, no, other person lordship. The registered sale deed issued by Jagdishwar Tiwari, deed and landlord, and so far the Hukumnama is concerned, the Yogendra Narayan Tiwari in favor of Prayag Mahato and Budhan Mahato by Sada Hukumnama dated 21/2/1941.
It is followed by Zamindari rent receipt.
He stated that rent receipt was issued and delivery of possession given, but the learned trial court held that the plaintiff and defendant had failed to prove their title loss.
The appellate court has discussed something in para number 8. The appellate court judgment lordship. Para 8. It has been further pleaded that para 2 the plaintiff incorrect that is denied by the defendant and khata number 7. No. The appellate court's judgment, the learned court below has discussed issue number 6, 7 and 8.
Yes, discuss. Para 8 lots, issue number 6, 7 and 8. Page 5 lots. The admitted position of suit land is
So they have discussed it. At page number 6, the record of right describes the suit land as Gan Majurwa Malik
Yes.
Sarkar Patti Kadim.
But it is a registered sale deed lordship.
So,
Right? It is
registered
a
sale
registered
deed,
sale deed lordship.
registered sale deed executed by Jag Nivas Narayan Tiwari.
Tiwari in favor of forefather of the plaintiff
Right.
in
Where
the
is
year
the,
1940.
he is the Zamindar. From
He is
where
the-
do we get? From where do we get this that he is the Zamindar?
According to pleading of the plaintiff lordship, he is the deed and landlord lordship.
Is it an admitted fact?
But it has been stated that
Did he file his returns, anything of that sort?
the return was to, there is no pleading that whether the deed and landlord the return was filed or not. But return, whether the return was filed or not, it is immaterial. In several places, lordship, in Ramgarh, in Aditpur, lordship, the deed and landlord was no return was filed lordship.
Merely
But the
because
rent receipt issued in the name of instead of the plaintiff till 2003-2004. Thereafter
till 2003 नहीं, oldest rent receipt कौन सा है? आप 1940 का डेट बता रहे हैं
जी,
उसके बाद
that is exhibit 2 and exhibit 2 by A Lordship.
that's right. What is the original rent receipt?
The
The
Lordship,
oldest.
I will bring the
So तो क्या ही होगा? The learned court below did not accept either the right of the plaintiff or appellant or the defendant respondent. दोनों के claim
दोनों
को
का
नहीं accept किया.
नहीं accept.
He was of the opinion that these two properties belong to state of Jharkhand.
Lordship. But there is a registered sale later. Unless
So
and until
merely because there is a registered
set
sale.
aside by the competent court of civil jurisdiction.
If I transferred Ranchi railway station in your name, you become the owner.
They cannot be Lordship. Cannot become the owner Lordship.
So therefore, the court has taken into consideration and decided that this property neither belongs to the plaintiff nor to the appellant, not to the defendant.
But Javandi was cancelled in the year 2003-2004 Lordship.
And the property is, as per the order of the revenue officer, the property is burial and tank.
Yes.
So,
Yes.
it's public land. Therefore, state of Jharkhand is unnecessary. You file fresh suit. क्या दिक्कत? इसमें लड़के क्या होगा?
That observation may be made.
I will not say anything. Why should I say? आप खुद ही advisor हैं. देखिए. Essay number 253 of 2016. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 8/2/2016 within bracket decree signed on 16/2/2016 passed by learned Additional Judicial Commissioner Roman 7 Ranchi, whereby title appeal number 32 of 2011 has been dismissed and the judgment dated 25/3/2011 decree signed on 7/4/2011 has been confirmed. The trial court judgment was passed by learned subordinate Judge Roman 8 Ranchi in title suit number 167 of 2002, whereby the suit was dismissed. This appeal has been filed by the plaintiff against the judgment of performance. The learned counsel for the appellant has submitted that the appeal has been dismissed primarily on the ground of non-joinder of necessary party, inasmuch as the state was not made a party in the proceedings. The learned counsel submits that the plaintiff did not claim any relief against the state, and therefore the state was not a necessary party. And in such circumstances, he submits that a substantial question of law be framed and be decided in this case. After hearing the counsel for the appellant, this court finds that the suit was filed by the plaintiff seeking that a decree may be passed in favor of the plaintiff in pursuance of registered sale deed and possession of the plaintiff be confirmed. And if the plaintiff is not found in possession, the possession be declared through the process of court. It was the case of the plaintiff that they are governed by Hanifi School of Mohammedan Law and land of Kevat number 12, Khata number 174, plot number 1521, area 4 acres, situated at village Dahu, PS Ormanji, PS number 26, district Ranchi, was the property purchased by the plaintiffs. The description of the property has been given in Schedule A of the plate. It was the case that land belonged to the landlord, namely Jagnivas Tiwari, son of Madhusudan Tiwari, who transferred the land to the forefather of the plaintiffs on 31/5/1940. And since then, the plaintiffs came in exclusive possession of the property and got their name mutated. And rent receipt was issued in their favor in the year 1965 on 21/4/1965. It was their further case that in the recent draft publication it was the further case that there was a proceeding under section 144 CRPC drawn between the parties, and ultimately the suit was filed. The defendants filed a written statement opposing the relief. And claimed that the suit was barred by limitation, and also claimed adverse possession. It was their further case that the land under Khata number 174 it was the further case that the land was settled by ex-landlord, namely Yogendra Narayan Tiwari, in favor of Prayag Mehto and Bhushan Mehto, both sons of late Mohan Mehto, by Sada Hukumnama dated 2/1/1941, after taking Nazrana, and the defendants were in actual cultivable possession of the land. Their fathers had improved the land through Kolkar and spent huge amounts, and that there is one tank and one graveyard and one graveyard shed over the plot in question. It was also the case that the plaintiff had no cause of action. It was also the case that villagers have been using the land as grazing ground. And earlier the villagers cremated dead body in one portion of the land. and there is a burning hut and tank. The entire sold property, in fact, was being used by the villagers since very beginning. The learned trial court framed as many as 9 issues for consideration, which are as follows. Both documentary evidences and oral and documentary evidences were led by the parties, including one certified copy of one mysterious case number 1 of 07-08, which was produced by the defendants marked as Exhibit A. The learned trial court took up the issue number 6, 7 and 8 at the first instance. And after considering the materials on record, the learned court held that the defendants have not been able to prove their right title or possession over the suit land. And so far as the plaintiff is concerned, the learned court discussed the case of the recorded findings of the plaintiff with regard to the plaintiff in paragraph 39 of the judgment. The learned trial court ultimately held that the land is Gair Manjurwa and the plaintiff was not in possession of the land. The findings of the learned trial court at paragraph 13 is quoted as under. Thus, ultimately, the learned trial court held that neither the plaintiff nor the defendants were able to prove their case. So far as the learned first appellate court is concerned, the issue number 6, 7 and 8 as framed by the learned trial court was taken up for consideration. The learned first appellate court recorded that as per the order passed in mysterious case number 1 of 2007-8, the suit property belonged to the state of Jharkhand. And accordingly, the learned first appellate court was of the view that the state of Jharkhand was a necessary party in the suit. The learned first appellate court was of the view that the applicant had challenged the position of the land and had demanded a declaration of his position, and it was not safe to pass the order without hearing the state. The learned court also recorded that the applicant had framed the appeal stating provisions of Section 4 of the Land Reforms Act, but the state had cancelled the Jamabandi of the appellant under the provisions of Chutanaka Tenancy Act, and ultimately held that the suit suffered from non-joinder of necessary party. This court finds that considering the nature of this court is of the view that considering the nature of land which was being put to use as stand and also burial ground as recorded by the learned trial court, the state of Jharkhand was certainly a necessary party in the suit. This court is of the view that the learned first appellate court has not committed any illegality, perversity or error of law in observing that the suit suffered from non-joinder of necessary party in as much as the state was not made party in the suit. This court finds no substantial question of law involved in this case, which is hereby dismissed.
Article 52, second appeal 596 of 2016.
Appellant. Day before yesterday, ये case call out हुआ था. है ना? उसके बाद पास ओवर किए थे कि 20,000 रुपये कॉस्ट करेंगे.
This is defendant second appeal against the judgment of reversal. This second appeal is under section 87(2) of Chutanaka Tenancy Act. Record of right was prepared in the name of in the name of defendant, original defendant, who died during the pendency of the suit. So, for rectification, the plaintiff filed a suit under section 87 before the settlement officer under section 87 CNT. Their application was rejected by the settlement court. They preferred appeal.
When was the record of right finally published?
Finally published, my lord.
And when was the case filed?
96. In the year 1995-96, it was prepared. Suit was filed for rectification. In the year 1996, title suit number 28 of 1996.
96.
Now, their specific case was that the suit property could not be recorded in the record of right because they are governed, they are scheduled tribe, and doubter cannot inherit. And other, nothing has been pleaded. Now, my lord, in the appeal, their appeal was allowed. What has happened during the pendency of the appeal? They tried to bring two documents. One, photocopy of judgment decree passed in one title suit 49/67 of 1953/4 and title appeal number 27/18 of 1955. Both were photocopies. First, these were not in their pleading. During the pendency of the appeal, they brought on the record photocopies under Order 41 Rule 27. Application filed by the plaintiff appellant under Order 41 Rule 27 was rejected by the learned first appellant. They challenged that order by filing writ petition. At that relevant time, writ petition was being filed. And in that writ petition, order rejecting grant of leave to tender additional evidence, which was rejected, that has been affirmed by this honorable. Now, which is at Annexure 9, page 90. So both these documents
Could not have been taken into consideration.
cannot be. Now, what the appellate court has allowed the appeal. Now, relying upon these two documentary evidence, and on the second ground, that doubter cannot inherit. So, his appeal was allowed. Kindly see, my lord, appellate court's judgment.
Read para 10.
Yes.
आधा पढ़ा ही नहीं रहा है.
This is on page 99.
हाँ, yes. Can you read it?
Here, it will be evident from the above discussions that against a definite case for the plaintiff of being agnates of recorded tenant, male heirs, and the claim of the defendant, we ourselves.
Male heirs तो नहीं लिखा है.
Agnates of the recorded tenants, उसके बाद एक वर्ड नहीं है, claim of the defendant / respondent of acquiring a title through a woman and non-existing Dhardamad was very weak and not to be believed upon. The claim of the respondent defendant through adverse possession was having no leg to stand. In the result, this civil appeal is allowed.
So the claim through women was discarded and
Yes.
adverse possession was also discarded.
Now, even if adverse possession, I'm not harping on that point. First, my submission is, my lord, the learned first appellate court has taken note. My lord will find it in, my lord, on page number 97, running or internal page 6. From Roman D, my lord. Per contra, my lord.
Yes.
Per contra, the defendant derives the claim of its right title interest through the daughter of the brother of the recorded tenant. It is stated that Sumai Urai married Konda Bhagat and she lived in cultivating possession of the land. Thus, the claim of the defendant respondent hinges around the derivation of title through Sumai Urai. It is argued that in custom of subdued tract, women cannot inherit right title and interest, and it is not the case of the defendant respondent that Konda Bhagat was living with the recorded tenant and he was adopted as a Ghazama. Thus, any title right interest said to be derived by Lakshmi Narayan Bhagat, son है उन daughter का, through Somai Iran remains doubtful. The revenue officer has mainly given its finding on the ground that the plaintiff of the case did not produce the documents. It appears from the evidence of PW3 that he has produced documents such as judgment of title suit, judgment of title appeal, and the order of SAR in which the defendant respondent lost the case. These documents have been marked exhibit by the court, but it was not marked exhibit. Rather, they filed under order 41/27.
All the three documents,
Yes.
including SAI court's order.
No, suit and title appeal.
Yes, SAI court's order is in whose favor?
Well, that is not very clear because SAR case has been filed by one SAR case has also been filed by us also, and that was allowed against some other persons. So, on the basis, thereafter, my lord will find that on the basis of these,
What is this certified copy? This is the original order. Page 31.
page 31.
This is the trial. Section 87.
Yes, that was the suit under judgment under section 87. This is the trial court.
Here you come to page number 41.
जहाँ तक उभय पक्षों के 42 लड़ाई हुई
41. 41 प्रतिवादी के विद्वान अधिवक्ता
प्रतिवादी के विद्वान अधिवक्ता का कहना है कि SAR केस 51/94/95 अपर समाहर्ता लोहारदगा के न्यायालय में दायर हुआ था, जिसमें वादी पहली सी वादी लक्ष्मी नारायण मीन्स डिफेंडेंट
Yes.
यस तथा प्रतिवादी जरी कुराव थे। इसी जीरो कुराव का लड़का हरिदास एवं है तथा वादी संख्या 4 एवं 5। SAR केस में लक्ष्मी नारायण के पक्ष में फैसला हुआ। फैसला की तिथि फैसला में अंकित है। इसी के आधार पर दिनांक 29/3/1997 ईस्वी को दखल दहानी भी दिया गया। सो दिस सपोर्ट्स द केस ऑफ द अपील। इस दखल के विरुद्ध कोई चुनौती नहीं किया गया है। जहां तक वादी का प्रश्न है उनकी ओर से एक भी लगान रसीद दाखिल नहीं किया गया है। उभय पक्षों की ओर से लिखित बहस भी दाखिल की गई है, जो कि अभिलेख में अलग से संधारित है। जहां तक प्रमाण का प्रश्न है, वादी की ओर से दिनांक 11/9/2007 को प्रमाण की छायाप्रति दाखिल की गई। तो जो होना चाहिए, तत्कालीन पीठासीन पदाधिकारी ने अगली तिथि आने 14/9/2007 को मूल कागजात दाखिल करने का आदेश दिया। आदेश के बावजूद वादी द्वारा मूल कागजात नहीं दाखिल किए जाने पर तत्कालीन पीठासीन पदाधिकारी श्री सो एंड सो ने अपने दिनांक इतना को आदेश फलक में लिखा है कि वादी अपना मूल कागजात दाखिल करने में विफल है। जहां तक छायाप्रति प्रमाण का प्रश्न है, उसे भी वादी द्वारा 11/8/2008 को वापस ले लिया गया है। ऐसी स्थिति में वादी के दावा का कोई आधार नहीं। वादीगण द्वारा मूल प्रमाण नहीं दाखिल किया जाना स्वतः स्पष्ट करता है कि वादी के वाद की दूरी पर दावा का दाखिल है।
वादी का केस क्या है?
वादी का केस बस यही है, मतलब बहुत छोटा सा केस है। वादी का प्लेट भी लगा हुआ है।
कहाँ है बट?
हाँ, मेरा बहुत विजिबल नहीं है टाइप को। मेरा काइंडली हैव अ लुक टू एनेक्सर 1 पेज 23। जीनियोलॉजी पेज नंबर 50 में है, रनिंग पेज में। वहाँ से माय लॉर्ड I can assist from there. Kindly see page first page 50, not running page 50. That is their memo of appeal. That is not my document. Page number 50.
Yeah, I just wanted to know, has he raised any dispute that the property cannot go to the daughter? Yes.
Yes. That they have stated, Miller. They have stated. Kindly see plain Miller page 20.
कहाँ है इनका ये plea?
क्या चीज?
That the property cannot go to the daughter.
देख, ये है that is not their case. They have taken in the memo of appeal as a ground. In the plain, my lord, can you see page number 20? Start from page number 23. Reading start from page number 24. That they say that the record of right has been prepared in the name of defendant. प्रतिवादी के नाम से तैयार हो गया है, जो बिल्कुल गलत है. Paragraph 3.
तो अपील में जाके नया केस बनाया.
Yes. When it is accepted, taking into consideration that this was a case fighting between two scheduled tribes, fairly submitted. Because ultimately the crux was involved regarding preparation of record of right. The court could see what is the to ascertain the truthness. Now, even then, the first appellate court could not have jurisdiction to take all those evidence, first which was not pleaded, second which was not admissible, and even though those were tendered as additional evidence, which was rejected up to the honorable court.
ये फीमेल हियरशिप के बारे में कितना दूर तक जा सकते हैं?
ये लोग कहीं नहीं, इनको मिलेगा ही नहीं. Page number minor, that's why minor for very fairly I am relying upon their own document 50. Running page minor.
You are the son of the daughter.
Daughter. मतलब भतीजी है, recorded tenant died issueless, उनकी भाई की बेटी है.
भाई की बेटी है.
हाँ. अब वो लोग भैयाद में है, मतलब
समझ.
थोड़े से.
कहाँ है क्वेश्चन ऑफ
Substantial question of law, Miller. Substantial question A is, my lord, with regard to marking and relying upon. Virtually, my lord, two substantial question of law may be taken down, my lord. One relating to the learned first appellate court has committed manifest jurisdictional error while relying upon the judgment passed in title suit and title appeal. In as much as the same was. And second is, my lord, whether the finding of the learned court of appeal below is beyond jurisdiction, holding that daughter cannot inherit the suit property.
On the ground that it is beyond the frame of the suit.
Yes.
Okay. Second appeal number 596 of 2016. This appeal has been filed under section 87 within bracket 2 of Tobacco Tendency Act. The learned counsel or the applicant has placed the plaintiff as Annexure 1 to the memo of appeal. And also the order passed by this court dated 8/2/2016, passed in WPC number 3041 of 2014. whereby the additional 8 to 2016 passed in WPC number 3041 of 2014. The Learned Counsel submits that on the bare perusal of the plaint, it was never the case of the plaintiff that the daughter could not inherit the suit property. And by referring to the order passed in the writ court, the Learned Counsel submits that before the appellate court, an application seeking additional evidence under Order 41, Rule 27, (1) of CPC was filed to adduce photocopy of judgment passed in title suit number 49 of 67 of 49/67 of 1953-54 and title appeal number 27/18 of 1959. The plea of additional evidence was rejected by the first appellate court, and the order was, and this court dismissed the writ petition challenging the order. The Learned Counsel submits that the Learned First Appellate Court, while deciding the case, has taken into consideration the very same documents in connection with which the additional evidence was declined, and has also taken into consideration that the female could not inherit the suit property. The Learned Counsel submits that the appellant hearing was claiming the suit property through female, that is daughter of the family, correct?
By now.
He submits that the finding was beyond the frame of the suit. He submits that substantial question of law be framed and be decided. Considering the aforesaid submissions and having gone through the materials placed on record, this appeal is admitted for hearing on following two substantial questions of law: whether the Learned First Appellate Court could have relied upon the Xerox copy of the order passed in title suit number 49/67 of 1953-54 and title appeal number 27/18 of 1959, in connection with which whether the Learned First Appellate Court could rely upon any of the documents which were refused to be permitted as additional evidence under Order 41 Rule 27(1) of the CPC. Whether the Learned First Appellate Court could have travelled beyond the frame of the suit while holding that the daughter was not, while holding, whether the Learned First Appellate Court has travelled beyond the frame of the suit while holding that the daughter and hence the defendant could not have inherited the sum property. Issue notice to the respondents under ordinary process as well as through speed post, for which recusals were filed within a period of 15 days from today. Let the records be called for from the first appellate court and also from the court of, ये जो भी डिटेल दिया है ना इसमें देना पड़ेगा, सेटलमेंट ऑफिसर का रिकॉर्ड है। यहाँ से सिविल कोर्ट ही ये रिकॉर्ड भेजता है, कौन भेजेगा?
आ जाएगा, अपीलेट कोर्ट में भी एक सेट रहता है, कोई इशू नहीं, आ जाएगा। सेटलमेंट दोनों को कर दिए, दोनों से आ जाएगा।
Was this case on November 10th? Awaiting service. Let this order to communicate.
Item 53, second appeal 599 of 2016.
The plaintiff is the appellant before minors last in court of appeals. The plaintiff has filed the suit for declaration of her right, title and interest, and also for injuncting the defendants from interfering in the suit property by the defendants. But the fact of this case is, madam, the suit property admittedly belongs to Khirodhar Singh.
Sorry?
Khirodhar Singh. After him, the property devolved upon Darbari Singh and Anirudh Singh, the son of the Khirodhar Singh. Now, they both partitioned the property half and half. Darbari Singh and Anirudh Singh. Thereafter, Darbari Singh gifted some property to her daughter-in-law, namely Gunjri, who is the wife of Durga Singh. So Darbari Singh was having one son who is married and whose wife is Gunjri. So a gift to deed was executed by Darbari in favor of her daughter-in-law. Now the daughter-in-law provides sale deed dated 16/5/81 sold 6 dismills of land to this petitioner who is daughter of Gunjri Devi.
To the plaintiff. To the plaintiff.
The plaintiff.
So,
The case of the plaintiff that she purchased the property in the year 1981 and subsequently she applied for mutation. The same was refused. In appeal, the appeal was also dismissed. On the ground that earlier also she applied for mutation and that was dismissed. Subsequently, after a lapse of 2 or 3 years, she again filed mutation application that was dismissed. Therefore, appeal was dismissed. Therefore, this is the cause of action for her filing the suit. Now, my lord, the trial court has come to the finding to that effect that there was a partition in between the parties, that is Darbari and Anirudh Singh, both the branches, of Khata number 29 of each plot. Here we are concerned only with
Khata
plot
number?
29. Here we are concerned only with plot number 4373, which is having an area of 31 dismills.
area?
31 dismills. So, my lord, both branch will get 15.5 dismills.
The trial court has held that there was previous partition.
They held that there was a partition, but they denied the gift deed. And subsequently, though they held that all the plots were divided half
Gift
and half.
by virtue of registered gift deed.
Yeah, there was a registered gift in 1939. But the appellate court, trial court has said that yes, there was a partition, but nothing has come on record. But as the parties were selling the property, and so there was a partition. So this finding is there of the trial court. Now, the trial court has also come to the finding that all the plots were divided half and half. We have brought on record an exhibit 1 by B. Exhibit 1 is the 1 by A is the sale deed of this petitioner Manas, this appellant, and 1 by is the sale deed of Bhuneshwar Singh and Mathura Singh, who are the sons of Anirudh Singh. They sold their property 15 and a half to their wives.
Kattha. Dismiss.
शायद पता नहीं डिसमिल अपनी वाइफ को बेच दी just to show that had they were claiming the entire 31 dismil of this plot, then they could have sold the 31 dismil. They sold only 15 and a half.
They were claiming only 15 and a half.
They were
Because
claiming only 15 and a half.
373 was 31 decimal.
But now the Malad
They sold only 50%.
Yes. Now Malad, in this case, what has happened? The trial court has come to the finding that though all the plots were divided half and half, but one plot 4316 was given to Darbari Singh, and this plot number 4373 was given in the branch of Anirudh Singh, that is Bhuneshwar Singh and Mathura Singh. There was no basis for this finding, madam. हम खाली finding पढ़ सकते हैं. दोनों कोर्ट का है, जो अपलेट कोर्ट सीधे लिखते हैं कि as it is found, कहाँ से उसका कहीं कुछ नहीं, हम दोनों का finding खाली पढ़ रहे हैं. इतना ही सत्य है.
ट्रायल कोर्ट का फाइंडिंग कितना?
ट्रायल कोर्ट का है रनिंग पेज 22 ऑफ द ट्रायल कोर्ट जजमेंट. Second paragraph. After going through the pleading and evidence, oral and documentary adduced by both the parties, I find that khata number 29 was recorded in the name of Kirudar Singh, father of Darbari Singh and Anirudh Singh. And after the death of Kirudar Singh, Darbari Singh and son of Anirudh Singh gave the land of his father and grandfather as property. Thereafter, they amicably partitioned the said land as per family arrangement, and accordingly they came in position half and half as per convenience over the plots of khata number 29. I also find that there was no any rule and custom of Jharkhand in the Muthachara school of law. I also find that because the land of khata number 29 was the ancestral property of Darbari Singh, so his son Durga Singh and his brother son Mathura Singh and Bhuneshwar Singh got the interest in the property of khata number 29 and other khata as a co-partner from the time of his birth. I also find Darbari Singh has no any right to give ancestral property of his father. This finding has no basis. I also find that the gift only made about the ancestral property for pious purpose, but after going through the recital of gift deed, I find this gift deed was not made for pious purpose. I also find that this gift deed never acted upon, because exhibit C by 2 to C by 4 shows that Musmat Gunjri executed sale deed about plot number 4316, total area 47 decimals, but according to the gift deed, he got only 24 decimals land of this plot. So it is clearly shows that Darbari Singh and Anirudh Singh partitioned their land by family arrangement as per convenience. They were in possession over plot wise of their khata, and plot number 4316 was fallen in possession of Darbari Singh, and after his death, it was fallen in the share of Gunjri Devi, and his minor son Mahadev Singh and Gunjri Devi sold the said plot. I also find that in gift deed no any boundary of her share about the gifted land are shown in gift deed, so it is not clear that on which side the gifted land is situated in respective plot and the plot number 4373. I also find that Gunjri Devi never came in possession over this plot, and accordingly the purchaser Savitri Devi never came in possession over this plot, because in mutation proceeding filed by the plaintiff in the year 1995 was rejected because her possession was not found over the purchased land. It is very much clear that sale deed about the suit land was executed in favor of plaintiff in the year 1981, but she did not come in possession over her purchased land till 1995, and thereafter a mutation case was filed in the year 2000. So I also find that the vendee plaintiff did not come in possession over her purchased land till now. I also find that the defendants are in possession over the disputed land and they are also noted her name and paying rent to the estate soon. I find and held that the land of Khata number 29 was not partitioned by meets and bonds in between Darwari Singh and his younger brother Anil Singh in the year 1939, but it was partitioned as per family arrangement and sake of convenience. Both brother and Anil Singh were in possession over the land of Khata number 29. I also find that plot number 4373 as per family arrangement fell in possession of Anil Singh. Accordingly, the plot number 4316 was in possession of Darwari Singh at the time of execution of due deed. I also find that Gujri Devi and his son Mahadev Singh succeeded the property of his father of Darwari Singh as legal heir. I also find that Darwari Singh had no any right, title and to execute give deed in favor of daughter-in-law about his ancestral and compulsory property because it was not executed for pious purpose and this deed was executed to deprive the share of Mahadev Singh, his grandson. I also find that plaintiff has no any right, title and position over her purchased land. I also find and held that the contesting defendant number 1 to 7 are in possession of the dispute. This is the finding of the court. Now, my lord, can be considered. It is not in dispute. The court is coming in the sale deed, that is exhibit 1 by it has been clearly mentioned that she being the owner of the property, she is selling the property. Just to fortify her case, this appellant has also brought a gift deed. Otherwise also, Gujri Devi was entitled, being successor, to succeed to the property and as per she sold the property.
She succeeded the property in the capacity of daughter-in-law.
No, after the death of her husband, because it has not come when her husband died, but it came ki she sold several property. Several cities has come where the Gujri has sold the property. And it was finding of the lower appellate court. I am just showing mothers. Madam, come page 9 of the lower appellate court, where the courts were formulated. Last 2 lines, madam. Exhibit 1, the sets Gujri Devi is no one but the mother of appellant plaintiff who is told 0.6 decimals of land
This
to
gift
plot.
deed dated 7/9/1939.
Gift deed.
It's gift deed.
1981 में सेल deed.
1981 में she only executed the sale deed.
She only executed. अब यहाँ देखा जाए ये आया ही नहीं कि उसका हस्बैंड कब मरा, लेकिन बहुत सा सेल डीड आया जो कि गुजरी देवी एक्सिक्यूट की है और दैट हैज बीन एक्टेड अपॉन. और जो
She had executed the sale deed. She sold 32 decimal of land
दैट वाज अदर सेल.
and she acquired only 24 decimal of land in plot number 4316.
दैट इज व्हाट द कोर्ट इज सेइंग.
Appellate court.
ये दूसरे प्लॉट के बारे में नहीं बोल रहा है.
इसी plot के बारे में.
नहीं इस प्लॉट के बारे में
Page number 10 में आई.
हां ये
Furthermore, I find that Gujri Devi had only acquired 24 decimal of land of plot number 4316 in the gift deed, but she sold 32 decimal of land through exhibits C/2, C/3 and C/4. Gift deed में कितना land?
गिफ्ट डीड में अगर 15.5 डिसमिल
24 decimal.
यहाँ हमको लगता है खाता का खाता को दिक्कत है. हमारा प्लॉट है जो 4316 इज डिफरेंट प्लॉट है.
You see, this court
Yeah,
records, just a
appellate-
moment, I find that Gujri Devi has only acquired 24 decimal of land of plot number 4316 in the gift deed, but she sold 32 decimal of land.
वो कह रहा है कि एक दूसरा प्लॉट है जहाँ पर कि इनको इतने 24 डिसमिल मिलना था, लेकिन वो 32 डिसमिल सेल की है. एंड देयरफॉर
इसके अलावा भी कोई गिफ्ट डीड है? गिफ्ट डीड किससे रिलेटेड था? प्लॉट नंबर 4316.
गिफ्ट डीड में है जो 8.5 एकड़ जमीन को
गिफ्ट डीड कौन से प्लॉट से रिलेटेड?
बोले तो सारा प्लॉट से 8.5 एकड़ खाता 29 में 8.5 एकड़ प्लॉट है. 8.5 एकड़ है जो
उसमें
उसके
ये
सारे प्लॉट का गिफ्ट डीड आधा का कर दिया.
आपने 81 वाला सेल डीड किस प्लॉट से
हमारा
related?
81 वाला सेल डीड है जो 4373. इसमें है जो खाली डिफेंडेंट साइड से और इधर से defendant says that several cell deeds were brought, those cell deeds were considered, उसका relevance क्या है, it has not been discussed. हम जो पढ़ रहे हैं
गिफ्ट डीड किस सारे प्रॉपर्टी से रिलेटेड
सारे properties
कहाँ लिखा
तो हम दिखाते हैं उसको पहले कुछ मिनट के बारे में मैंने ट्राई कर लिखा है But appellate court has considered this aspect, give deed or no give deed. Otherwise, also she succeeded to the property. वही हम दिखाना चाह रहे हैं खाली इतना देख लीजिए कि पेज 9
भाई
में
ये 3 पॉइंट ऑफ डिटर्मिनेशन बना है
हाँ इसका फर्स्ट पॉइंट ऑफ डिटर्मिनेशन
पहला वाला पॉइंट में बोला है कि जितना गिफ्ट डीड में नहीं मिला था उससे ज्यादा बेच दिया
एक प्लॉट
आई डू नॉट
तो ओनली विथ रिगार्ड टू वन प्लॉट में वही हम दिखाना चाह रहे हैं खाली उसको देख लीजिए कि यहाँ पर पहले पेज 9 में है जो लास्ट 2 लाइन पढ़ रहे हैं एग्जिट 1 इज द सेट गुजरी देवी इज नो वन बट द मदर ऑफ appellant plaintiff who sold 0.6 dismiss of land food plot in favor of appellant, although I do not find the story of such gift in recital of the certified copy of the sale deed. So she has not said, she sold the property being the owner of the property. Now, my lord, thereafter, the learned court considers about whether there was a partition or not. And finally, in para 21, the court says, last 3 lines I am reading my note of the para 21, page 11. Therefore, it can be safely said that there has been an oral family arrangement between ancestor of the parties after the death of recorded heir, and by that method there was virtual partition with separate share of possession of the ancestral property, including the suit plot. Now, Manat para 22, he starts with. As held above, the said Darbari Singh had no right to give the co-partner ancestral property to the vendor of the appellant plaintiff, and the said deed was also not executed in consonance with Union Registration Act.
yes यहाँ पे pause करिए
No.
why is it said that it is not in consonance with
Yes,
the
that is what I am saying, Manat. The only basis is as held above. Point of consideration starts from page 10, page 9. यहाँ पर कहीं इसके बारे में कुछ नहीं लिखा है, सिर्फ इसका यही बेसिस है कि एज हेल्ड अबव.
ये जो गिफ्ट डीड है आप बोलते हैं रजिस्टर्ड डॉक्यूमेंट है
हाँ.
ट्रायल कोर्ट के जजमेंट से पता चलेगा ना एग्जिबिट लिस्ट दिखाइए
एकदम चल जाएगा जो ट्रायल कोर्ट में एकदम मेंशन
हाँ,
है
बताइए।
दिखाना है.
दिस इज एग्जिबिट नंबर
एग्जिबिट नंबर 1 पूरा लिखा है ट्रायल कोर्ट में. यहाँ देखो पेज 8 में लिखा है एग्जिबिट 1 इज द सीसी ऑफ रजिस्टर्ड गिफ्ट डीड नंबर 2809 dated 7/9/39 executed by Darbari Singh son of Firoza Singh in favor of Mafat Gujri wife of Durga Singh about 8.12 acres land with house under खाता number 29 village Pargana and PS Kotarma district. और हम जो एविडेंस लाए जो एग्जिबिट 1 बाय माय सेल डीड exhibit 1 by is the sale deed of my opponent. They are selling only 15.5. The plot consists 31 dismiss. Appellate court जो है जो यहाँ आ रहा है
the gift deed also did not have any specific boundary is that correct?
हाँ बाउंड्री हाफ एंड हाफ सारा प्लॉट वो तो ट्रायल कोर्ट का फाइंडिंग में आया जो सारा प्लॉट हाफ एंड हाफ बटा विथ कन्वीनियंस. कोई ऐसा नहीं आया कि पार्टीशन का कोई रजिस्टर्ड डॉक्यूमेंट नहीं आया रिकॉर्ड में, लेकिन बोथ द कोर्ट का फाइंडिंग है कि देयर इज पार्टीशन. और उसके बाद हम
सब्सटैंशियल क्वेश्चन ऑफ लॉ नंबर 20 से हो जाएगा।
हो जाएगा। अब बी और सी कर दिए। लेकिन अपलेट कोड अपने आए कि अगर गिफ्ट डीड को हम हटा भी देते हैं तो गुंजरी का टाइटल आता है, गुंजरी अपनी बेटी को करे जाए, और अदरवाइज बेटी इज ऑल्सो कम इज ए कोपार्टनर ना, और उसका अपना राइट है।
Heard the learned counsel for the appellant. The learned counsel for the appellant has submitted no assent. His appeal is admitted for final hearing on the following substantial question of law. Whether the learned courts, दोनों कोर्ट बोला है ना, gifted null and void, दोनों कोर्ट,
दोनों कोड।
whether the learned courts have committed perversity while declaring the gift deed dated 7/9/1939, registered gift deed dated 7/9/1939, within bracket exhibit 1 होना चाहिए ना,
हाँ एग्जीक्यूट हो
आप exhibit 2 कैसे लिख दिए उसमें?
जाए।
Exhibit 1 as null and void. ये गिफ्ट डीड सस्टेन करेगा तो बाकी सब सस्टेन कर जाएगा,
गिफ्ट सक्सेसफुल करेगा।
इतना सही हो जाएगा। इशू नोटिस to the respondents under registered cover as well as speed post. For which for which requisites be filed within a period of 2 weeks from today. Post on 10th of November awaiting service. One for the LC.
Item 54, second appeal 216 of 2017.
May please your lordship. This is my lord. The plaintiff's second appeal against the judgment of affirmation. Suit was filed, my lord, for declaration of title and confirmation of possession in the alternative, my lord, for recovery of possession and, my lord, for grant of injunction restraining the defendants from interfering with the peaceful possession of the plaintiff over this land. Now, my lord, suit property is 30 decimals out of plot number 1210 of khata number 18. In this case, my lord will find that, my lord, settlement was made in favor of the plaintiff in the year 1947 by virtue of customary hukumnama, followed by delivery of possession, my lord, and grant of rent receipt, which has already been exhibited.
What is the oldest rent receipt?
Lord. Thereafter, my lord, at the instance of defendants.
What is the oldest rent receipt? And where is the hukum exhibit number?
'85, '86. Now, Lordship,
85, 86 is the oldest rent receipt.
oldest. Thereafter, my Lord,
Where is the hukum number exhibit number?
Hukumnama, Lordship, it has been exhibited. I'll show, my Lord.
Exhibit 7.
Exhibit 7.
तो जमींदारी रेंट रिसीट तो नहीं है ना आपके पास?
नहीं, जमींदारी रेंट रिसीट भी होगी, एग्जिबिट 1 सीरीज।
तो वही तो पूछ रहे सबसे पुराना रेंट रिसीट कौन सा?
जमींदारी रेंट रिसीट।
हाँ, सबसे पुराना डेट बताइए और एग्जिबिट नंबर बताइए।
हाँ, बताइए। $49 का 7/5/1949।
एग्जिबिट नंबर
उसके बाद 12/7/1952।
ये बताइए ना एग्जिबिट नंबर।
एग्जिबिट 1 सीरीज है वो।
अच्छा, 1 सीरीज। ये तो सरकारी लगान रसीद है।
उसी के साथ ये भी एग्जिबिट हुआ हुआ है, हमारे पास कॉपी भी है।
आप जजमेंट से दिखाइए कहाँ है?
हम दिखा। Lordship में कहीं इसी पैरा 22 of the trial court judgment, internal page 20 Lordship।
Yes.
दस्तावेज प्रदर्श 1Q तथा 1R जमींदारी लगान रसीदों के द्वारा मात्र यह तथ्य साबित होता है कि वादिनी कुर्ती देवी के द्वारा लगान का भुगतान जमींदार को करके उसकी रसीदें प्राप्त की गई, परंतु उसके आधार पर विवादित जमीन पर वादनी का स्वत्व स्थापित नहीं किया गया। वादनी की ओर से अभिलेख पर साबित कराए गए दस्तावेज प्रदर्श 1 से 1P के अवलोकन से मात्र यह साबित होता है कि वादनी द्वारा राज्य सरकार को लगान अदा करके उसकी रसीद प्राप्त की गई, परंतु विवादित जमीन के संबंध में वादनी के जमाबंदी को DCLR द्वारा वाद संख्या इतना में पारित आदेश के द्वारा रद्द कर दिया। What happened, my lord? A proceeding was initiated at the instance of the defendant for cancellation of long-standing jamabandi, which was cancelled, my lord,
Defendant was claiming on what ground?
by virtue of the defendants are claiming, my lord, by virtue of hukumnama settlement.
They are
through
also
hukum. Yes,
claiming
lord.
through
Or,
hukumnama.
sir, yes, lord.
Their hukumnama is dated.
They have claimed, my lord, that the land was settled in the year 1925.
They also have zamindari rent receipt.
जमींदारी रेंट रिसीट,
Since when?
लॉट।
ये वाला पैरा 24 में है।
हाँ, 20। प्रतिवादी गण की ओर से साबित कराए गए दस्तावेज प्रदर्श C2, C4 तथा E3 के समय वादनी के संबंध में SDM के द्वारा प्रावधानों को दाखिल किया गया था, द्वारा अंचल अधिकारी ने अपना जांच प्रतिवेदन समर्पित किया और संबंधित अनुमंडल हजारीबाग जिसे प्रदर्श की गई
उनका टाइटल डिक्लेयर किया गया है।
उनका टाइटल डिक्लेयर किया और हमारा हुजूर केवल डिसबिलीव किया गया इसी ग्राउंड पे कि प्लेंटिफ हैज नॉट बीन एग्जामिन्ड इन दिस, ऑल्दो my lord husband of the plaintiff has been examined and both the documents, my lord, hukumnama and rent receipt has been exhibited,
उनका हुक्मनामा और रेंट रिसीट का डिस्कशन कहाँ पर है? और उनके फेवर में जो फाइंडिंग किया गया है वो
जी।
कहाँ पर है?
पैरा 29 हुजूर देखते हैं, पेज 24। इस प्रकार उभय पक्षों की ओर से अभिलेख पर साबित कराए गए दस्तावेजी साक्ष्यों के आधार पर यह तथ्य पूर्ण रूप से साबित हो जाता है कि विवादित जमीन पर वादनी को न तो कोई स्वतंत्र प्राप्त है और न ही दखल कब्जा। विवादित जमीन के संबंध में वादनी कुंती देवी के पक्ष में जदुवीर सिंह को हुक्मनामा द्वारा बंदोबस्ती करने का कोई हक प्राप्त नहीं है और उसके द्वारा की गई बंदोबस्ती के आधार पर विवादित जमीन पर वादनी का कोई स्वतंत्र प्राप्त नहीं होता। इसके साथ ही वादनी द्वारा विवादित जमीन के बंदोबस्ती से संबंधित हुक्मनामा की वैधता को भी साबित नहीं किया गया। Although my lord, this document has been exhibited.
They say that even the person who had executed the hukumnama did not have the jurisdiction to do so.
But my lord, yes.
Was not competent to issue wakalat.
But my lord, the ex-landlord had full right.
What
and
about the
authority.
defendant? I want to
Lordship,
see the
Lordship,
discussion
Lordship.
of the defendant. आप पैरा 30 भी पढ़ी।
हाँ सर।
वादिनी साक्षी संख्या 3 रामप्रकाश सिंह है जो वादिनी कुंती देवी के पति हैं और स्वयं जमींदार। पैरा 30 खुद ही जमींदार है, तो ये जमींदार ये
वादिनी की ओर से परीक्षित कराए गए मौखिक साक्ष्यों में से सर्वाधिक महत्वपूर्ण सभी साक्षी वादनी साक्षी संख्या 3 रामपुकार सिंह है जो कि वादनी कुंती देवी का पति और स्वयं जमींदार है। इस साक्षी ने अपने मुख्य परीक्षण में कथन किया। Now lordship may kindly see the averments made in it.
Yeah, we do not know it. This person is your witness and your husband.
But my lord, Rampukar Singh, three persons have executed hukumnama in favor of the plaintiff. I have stated in my claim.
तो तीन
हुकुमनामा is on the
होना
record. नहीं, एक ही तीन लोग के द्वारा दिया गया था और तीनों का नाम है रामपुकार सिंह भी है, लिखे हुए।
कहाँ लिखा है
ये
आपके
प्लेंट में लिखे हैं।
प्लेन से?
त्रिवेणी सिंह, रामपुकार सिंह एंड दिनेश्वर सिंह।
तीन आदमी कैसे देंगे?
इस तीनों इस लैंड को इनहेरिट किए।
आगे बढ़िए ना, पैरा 30 को आगे चलिए।
इस साक्षी ने अपने मुख्य परीक्षण में कथन किया है कि खाता संख्या 18 खेवट संख्या 2/3 ग्राम केसुआ की जमीन बकास मालिक फूलो कुंवरी के नाम में दर्ज। फूलो कुंवरी खाता संख्या 18 की जमीन की देखभाल अपने एकमात्र देवर जदुवीर सिंह के द्वारा करती थी। फूलो कुंवरी की मृत्यु निसंतान हो जाने के कारण इसके हिस्से की जमीन जदुवीर सिंह को प्राप्त हुई और जदुवीर सिंह की मृत्यु के पश्चात उसके 3 पुत्रगण त्रिवेणी सिंह, रामपुकार सिंह और दिनेश्वर सिंह को प्राप्त हुई, जिसके आधार पर वे तीनों खाता संख्या 18 की कुल जमीन रकबा 9.62 एकड़ पर बकास मालिक दखल में आए और उसमें से 8.49 एकड़ जमीन 700 रुपए सलामी लेकर हुकुमनामा दिनांक 2 माह व दिसंबर 2003 के द्वारा वादनी श्रीमती कुंती देवी के नाम से बंदोबस्ती करके दखल कब्जा में दे दी। वादनी जमाबंदी प्राप्त करने के पश्चात 8.49 एकड़ जमीन की मालगुजारी अदा करके अपने नाम में रसीद प्राप्त करने लगी, लेकिन वादिनी के गोतिया मथुरा सिंह तथा बैद्यनाथ सिंह ने 87 ईस्वी में न्यायालय भूमि सुधार उपसमाहर्ता हजारीबाग के समक्ष लगान रद्दकरण वाद संख्या इतना दाखिल किया जिसमें वादिनी का जमाबंदी रद्द कर दिया। मथुरा सिंह एवं बैद्यनाथ सिंह के वकील ने विविध वाद संख्या में जाली हुकुमनामा बनाकर रकबा 30 डिसमिल जमीन पर अपने स्वतंत्र का दावा किया, जिसके आधार पर भूमि सुधार उपसमाहर्ता हजारीबाग द्वारा विविध वाद संख्या 2687 में पारित आदेश दिनांक 20/2/89 के द्वारा विवादित जमीन रकबा 30 डिसमिल के संबंध में प्रतिवादीगण परमेश्वर दयाल एवं केशल लाल के नाम से जमाबंदी खोलने का आदेश पारित किया गया। भूमि सुधार उपसमाहर्ता हजारीबाग के द्वारा विविध वाद संख्या 2687 में पारित आदेश दिनांक 20/2/89 के विरुद्ध समाहर्ता हजारीबाग के समक्ष अपील संख्या 2389 दाखिल किया गया, जिसमें सुनवाई के पश्चात पारित आदेश दिनांक 6/3/91 के द्वारा खारिज कर दिया गया और विवादित जमीन रकबा 30 डिसमिल के संबंध में प्रतिवादी गण के नाम में जमाबंदी खोलने तथा प्रतिवादी गण के पक्ष में लगान रसीद काटने के लिए भूमि सुधार उपसमाहर्ता हजारीबाग के आदेश को उचित पाया गया, जिसके कारण वादनी को वर्तमान वाद संस्थित करना पड़ा। इस साक्षी ने अपने मुख्य परीक्षण के पहले 2, 4 तथा 5 में कथन किया है कि खेवट संख्या 2/3 की जमीन कुंवरी के नाम से बकास्त मालिक के रूप में दर्ज थी, जो अपने एकमात्र देवर जदुवीर सिंह के द्वारा उस पर खेती करवाती थी। फूलो कुंवरी की मृत्यु के पश्चात उसकी संपूर्ण जमीन जदुवीर सिंह को प्राप्त हो गया, जबकि वादनी की ओर से यह अभिलेख पर प्रस्तुत किए गए दस्तावेज प्रदर्श 2 के अवलोकन से यह तथ्य साबित होता है कि खेवट संख्या 2/3 का अपना कोई स्वतंत्र अस्तित्व नहीं था, बल्कि यह खेवट संख्या 2/1 तथा 2/2 के सम्मिलात मालिकान के रूप में दर्ज था तथा खेवट संख्या 2/1 तथा 2/2 के अनुसार
अब पेज नंबर 32 में आइए
जी। प्रतिवादी गण की ओर से परीक्षित कराए गए प्रतिवादी साक्षी संख्या 1 केसर लाल अधिवक्ता वर्तमान वाद में प्रतिवादी संख्या 2 के रूप में पक्षकार। इसने अपने मुख्य परीक्षण के दौरान अपने लिखित कथन में किए गए कथनों की पुष्टि की है। इसमें मुख्य परीक्षण के दौरान कथन किया है कि विवादित जमीन ग्राम केसुरा, थाना मुफस्सिल, जिला हजारीबाग, अंतर खाता संख्या 18, प्लॉट संख्या 1210 में रकबा कुल 30 डिसमिल ग्राम केसुरा के भूतपूर्व जमींदार कुंवर अभिलाष सिंह, कुंवर जदुवीर सिंह तथा फूलो कुंवरी थी। कुंवर जदुवीर सिंह को ही जद्दू सिंह कहते थे। इस साक्षी के कथनों की पुष्टि वादनी की ओर से साबित कराए गए दस्तावेज प्रदर्श 2 से भी होती है। इसने यह भी कथन किया है कि मसोमा कुंवरी के निसंतान मृत्यु हो जाने कारण उसके हिस्से की जमींदारी से सीमित जमींदार अभिलेख सिंह तथा कुंवर जदुवीर सिंह के बीच आधा आधा बंट गई। अभिलेख सिंह की मृत्यु के पश्चात उसका एकमात्र पुत्र कुलेश्वर सिंह जमींदार हुआ। कुंवर कुलेश्वर सिंह हुक्मनामा के द्वारा अन्य जमीनों के अलावा विवादित जमीन में से 1 कट्ठा 14 धूर तथा कुंवर जदुवीर सिंह ने दूसरे हुक्मनामा द्वारा 5 कट्ठा 13 धूर जमीन अन्य जमीनों के साथ प्रतिवादी गण की दादी राधा देवी के नाम में बंदोबस्ती कर दिया, जिस पर वह दखल कब्जा में आ गया और उसके पश्चात प्रतिवादी गण उस पर दखल कब्जा में। प्रतिवादी ने दोनों जमींदारों को किए गए बंदोबस्ती से संबंधित अलग अलग हुक्मनामा को 30 वर्ष से अधिक पुराना होने तथा उसे अपने दादी के कब्जे से उनकी मृत्यु के पश्चात प्राप्त होने का कथन किया और यह भी कथन किया कि उसे बैंक से ऋण लेने के लिए यूनाइटेड बैंक हजारीबाग में जमा किया गया था। वहां से दोनों हुक्मनामा को वापस लेकर उसे परमेश्वर दयाल बनाम बिहार राज्य से संबंधित स्वतंत्रवाद संख्या 105/87 में न्यायालय अपर मुंसिफ हजारीबाग के समक्ष दाखिल किया, जिसके निर्णय तथा स्वतंत्र अपील संख्या 66 और 90 राज्य बनाम परमेश्वर दयाल के निपटारा के पश्चात हुक्मनामा इस साक्षी को वापस प्राप्त हुआ, जिसे इसने न्यायालय में दाखिल किया और उसे क्रमशः प्रदर्श जे तथा J1 अंकित किया गया। इस साक्षी ने यह भी कथन किया कि विवादित जमीन का मालगुजारी पहले जमींदार को देते थे और जमींदारी मालगुजारी रसीदों 4 अदद को 30 वर्ष से अधिक पुराना होने पर प्रदर्श B से B3 अंकित किया गया। इस साक्षी ने यह भी कथन किया कि वादनी के ससुर कुंवर जद्दू सिंह थे। उनकी मृत्यु के बाद उनके पुत्र त्रिवेणी सिंह, राम पुकार सिंह, दिनेश्वर सिंह ग्राम केसुरा की जमींदारी का आधा हिस्सा उत्तराधिकार में प्राप्त की।
ये तो दोनों का ही तो हुक्मनामा का कहानी है।
तो दोनों का हुक्मनामा का हुजूर, और कहानी ये है कि डिफेंडेंट हुजूर हमारा लॉन्ग स्टैंडिंग जमाबंदी को कैंसिल करा लिए, जबकि डीसीएलआर को पावर नहीं कैंसिल करना। डीसीएलआर से के कोर्ट से कैंसिल हो गया और उसके बाद एडिशनल करेक्टर उसको एफर्म कर दिया, उसके बाद ही हम सूट फाइल किए। हम तो पोजीशन में थे ही और हम हुजूर हुक्मनामा से क्लेम कर रहे हैं सेटलमेंट कपल्ड विद ग्रांट ऑफ रेंट रिसीट फॉलोड बाय डिलीवरी ऑफ पोजीशन और जमींदारी
also claiming
और जमींदारी रेंट
they are
रिसीट।
also claiming through hukumnama and followed by rent receipt.
But my lordship, may kindly see, my lord, Exhibit 7. Hukumnama has duly been executed by the ex-landlord Milord, by which the suit land Milord has been settled in favor of the plaintiff, coupled with grant of renticide followed by delivery of possession, which confer Milord valid rayati right upon the settlement. And they have purposely filed Milord case before the DCLR for cancellation of long-standing Jamabandi running in the name of the plaintiff.
Even your possession over the suit property was not.
But Milord, rent receipt was issued in favor of the plaintiff, Lordship may kindly see, by the revenue authorities, which is a strong evidence of possession. Lordship has decided, Lordship. So this is the case, Lordship, and this is a fit case to be admitted, Lordship. This is my case.
आपका substantial question of law का
Lordship, substantial question of law. Number 3, Lordship.
कौन सा judgment है? पार्टी का नाम बताइए ना. उगनी देवी.
उगनी देवी का 68
68 पटना
PLJR भी है.
68 पटना एंड 68 PLJR. एक तो में पेज नंबर 3, एक तो पेज नंबर 302.
उगनी देवी का citation दे देंगे.
उगनी देवी का
लिख देंगे इसमें. मतलब question of law में ही लिख देंगे.
जी.
For the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the plaintiff has lost in both the courts, but the courts have failed to appreciate that customary law coupled with grant of rent receipt, zamindari rent receipt followed by delivery of possession is sufficient to prove title over the property. He has referred to the judgment passed by this court, by Honorable Patna High Court in the case of Ugni Devi. Citation देंगे. He submits that this aspect of the matter has not been properly considered and accordingly substantial question of law be framed and admitted. Considering the opposite submissions, this appeal is admitted for final hearing on the following substantial question of law. Against the mandate of law, in the light of the judgment passed in the case of Ugni Devi. इतना ऐड कर देंगे इसमें. Roman 3. Issue notice to the respondents for which the recusals under ordinary process has been supposed to be filed within a period of 2 weeks from today. Let the records be called for from the concerned court. Pose this case on 11th November. Citation लिख के दीजिए.
हम लिख के दे.
Item 55, second appeal 238 of 2017.
Appellants are the original defendant number 1 and 2. What has happened? One partition suit has been filed in the database. The notices were issued, and upon notice, all the defendants, including the appellants, appear. Then the learned trial court dismissed that suit on the ground of the territorial jurisdiction. What has happened then? The entire suit land is of the district Latehar of Chandwad under district Latehar, and one piece of the part of the suit of the Datenganj was added with this partition suit, and suit was filed in the Dardenganj.
It was partition suit.
It was a partition suit. Thereafter, the suit was dismissed on the ground of the territorial jurisdiction. Our misapplication, miscellaneous appeal was filed. In the miscellaneous appeal, we did not receive any notice, and but that miscellaneous appeal was allowed, and suit was the suit was remanded back to the.
How is it partition suit? One side is the bank के साथ partition suit
बैंक
लगा-
नहीं है my lord.
कौन सा appeal है?
Serial 55,
238 और 2018
238, 2017,
2018
17 का लिस्ट में my lord.
जिसमें 17 का है,
जी
जिस पे देखिए तो 17 का है। ये 2018 का केस आपने देखा। 2018 लगता है गलती से ये 17 की जगह 18 का। चलिए इसको कल लिस्ट कर दीजिए।
कल सेकंड हाफ में स्पेशल बेंच
17 18 दोनों
अलग केस है, ये 17 है।
17 दिया। कल स्पेशल बेंच क्या है इसके लिए?
अर्ली बेल का जो था रिजेक्टेड स्पेशल बेंच बना हुआ है काइंड ऑफ मैटर में सेकंड हाफ में लगा हुआ है 2-3 मैटर, इसलिए खाली सेकंड हाफ के लिए इसको मंडे को रख दीजिएगा।
नहीं अभी मिल गया।
Then miscellaneous appeal was filed, and by the miscellaneous appeal the suit was remanded. After that remand, no notice was issued to us. Even then we have not received any notice. Then on this ground, according to me, Lordship, the one of the substantial question is whether after the remanding back of the suit, fresh notice is required or not. Apart from that,
After the matter was remanded, you did not participate.
I did not receive any notice.
Did you participate or you did not participate?
Neither I received notice nor I participated because I was not even knowledge
No,
of.
you were represented. What? How do you say that?
I was representing in before remanding back my.
We do not know.
That has been written in notice.
तो इससे क्या मतलब है?
Apart from that, the second.
आपके वकील साहब अपील कर रहे थे ना?
नहीं, डिफेंडेंट के तरफ से दूसरे हम केवल डिफेंडेंट नहीं थे. We were defendant number 1 and 2. Others are defendant from the other co-partner. They were represented क्योंकि मेरी एक जमीन उनको भी मिल रही थी, इसलिए वो जो है पार्टीशन सूट में वो एग्री कर देते टू द प्लेंटिफ. Apart from that, the suit property में there was one suit property which was
वहाँ है ट्रायल कोर्ट का जजमेंट, पेज नंबर बताइए।
ट्रायल कोर्ट का जजमेंट माय लॉर्ड, इट स्टार्ट्स फ्रॉम पेज नंबर 10. पेज नंबर 10 में the relevant part kindly देखा जाएगा my lord. Page number 18, internal page 9 of the trial court judgment.
जब ट्रायल कोर्ट का फ्रेश जजमेंट हुआ तो एविडेंस उसके बाद हुआ नहीं?
एविडेंस उसके बाद ही हुआ. शुरू में आया प्रिलिमिनरी ऑब्जेक्शन हुआ रिगार्डिंग टेरिटोरियल जुरिडिक्शन, उसी पर वो केस डिसमिस हो गया. देन मिसलेनियस अपील फाइल हुआ. मिसलेनियस अपील का कोई नोटिस नहीं मिला. इवन फॉर द ब्रिंगिंग द रिकॉर्ड मिसलेनियस अपील का सर्टिफाइड कॉपी के लिए भी अप्लाई किए, अभिलेख उपलब्ध नहीं है करके एक हमको रिटर्न कर दिया गया. अपार्ट फ्रॉम दैट फ्रेश नोटिस के बाद जब
कहाँ लिखा है कि इसमें कोई अप्लाई नहीं हो रहा?
ये काइंडली सी पेज नंबर 37, पेज नंबर 18, इंटरनल पेज 7. अपलेट कोर्ट की परवर्सिटी का इस फाइंडिंग पर भी हम लेके आए हैं माय लॉर्ड. लास्ट पर वर्तमान संपत्ति में मौजा 12 लोटा मौजा चंदवा में अवस्थित है, जो मालूमात जो जिला पलामू एवं लातेहार में पड़ती है. अतः इस क्षेत्राधिकार का प्रश्न मामला प्रस्तुत है. इस बिंदु पर अवर न्यायाधीश प्रथम डाल्टनगंज पलामू के आदेश इतना के विरुद्ध में माननीय जिला न्यायाधीश पलामू में मिस अपील संख्या सच सच दाखिल किया. उसके बाद ऑर्डर कोट किया गया. इस ऑर्डर में काइंडली सी माय लॉर्ड नेक्स्ट पेज, लास्ट पैरा के 5 लाइन ऊपर. moreover when no written statement has yet filed by the defendant respondent number 1 and 2, even no preliminary issue on this question of law could be settled and decided. यह कह के इन्होंने रिमांड बैक कर दिया. thereafter there is no finding कि हम अपीयर किए हैं या नो फ्रेश नोटिस हुआ है. वो कंसीडर कर लिए क्या क्या जो है एग्जिबिट किया गया है और उसके बाद सूट को डिसाइड कर दिया।
कहीं आपका रिटन स्टेटमेंट क्लोज तो नहीं हो गया?
नहीं, रिटन स्टेटमेंट मैंने फर्स्ट टाइम में ही इसमें लिखा है रिटन स्टेटमेंट क्लोज भी नहीं हुआ था, इसलिए तो अपीलेट कोर्ट में लिखा है कि नो रिटन स्टेटमेंट हैज बीन फाइल्ड। अपीयर करने के बाद प्रिलिमिनरी इशू यही की है कि टेरिटोरियल जुरिडिक्शन है कि नहीं, और सूट लैंड में एक लैंड वैसा लैंड था 57 डिसमिल का जो मेरे फादर के नाम से बंदोबस्त हुआ था। नाउ विदाउट एनी एविडेंस that this joint family, my separate property has been clubbed with the joint Hindu property, ये decide कर दिए गया on the presumption कि since there is a joint family, that's why it is a joint Hindu family property. There is no finding on this, now though the issue number 3 has been formulated on this point, कि whether there is a jointness of property or not, considering all the documents, on the basis of considering all the documents and the judgment of the Honorable High Court and Supreme Court, it has been said that all are having right of 1/4 share, including the self-acquired property of the father of the applicants. And trial court has, sorry, the appellate court, first appellate court has ordered in holding कि हम लोग जो हैं, we were already party to the appeal, but even though he has not stated that we are party to the appeal, whether we have given a notice has been received by us by the trial court or not, or we have participated on the presumption. That was the second question. Few questions, if my lord will permit me, I have, according to my knowledge, I have drafted substantial question. If my lord will permit me, then I will pass it out.
Did you raise this plea before the first appellate court?
फर्स्ट अपलेट कोर्ट में भी नोटिस हमको नहीं, सॉरी, फर्स्ट अपलेट कोर्ट में हमने इसको इस बात को लेके आया था, काइंडली सी, फर्स्ट अपलेट कोर्ट में दे हैव डिसाइडेड ऑल द 3 इश्यूज ऑल टुगेदर, इशू नंबर 3, 4 and 5, and considering all the evidence.
आपसे पूछा फर्स्ट appellate court में आपने इस grievance को उठाया था that you were never served notice the demand and you had no idea about the case?
Kindly see paragraph 1. यह उल्लेखित है कि अपील के अंतिम सुनवाई के दौरान उत्तरवादी गण परिसीमा के विषय को उठाने के स्वतंत्र रहेंगे। अपील के औपबंधिक रूप से प्रविष्ट किए जाने पर उत्तरवादी गण समस्त कार्रवाई के उपरांत कालांतर में परिवार के क्रम इस न्यायालय में हस्तांतरित हुआ, जो वर्तमान में निलंबित और नंबूत है।
आपसे सवाल पूछ रहे हैं उसकी का जवाब दीजिए ना। Did you raise this plea before the first appellate court that you were never noticed after remand? There is a presumption of jointness.
There is a presumption only since only on the ground that there is a joint Hindu family property. And Honorable Supreme Court has held in the case of, which has later on followed in the case of D. S. Lakshmaiya and another, then only on the presumption that there is a jointness of joint Hindu family property, it cannot be presumed that self-acquired property is
No,
clubbed.
certainly it will not be presumed, but there is a presumption with regard to joint Hindu family property. Then under such circumstances, if a person who claims that it is his self-acquired property, he has to prove it.
I have
The
not been
onus is
given
on the
opportunity
person.
apart from that, my lord. Kindly see, it was their claim and they have stated for a moment, kindly their claim, the portion which affects me. Kindly see, your lordship, page number.
The proceeding is not ex parte against you.
Proceeding initially, your lordship, notices were issued before remanding back. after remanding back, no notice was issued to us. I had no knowledge, even the filing of the appeal or even the reopening of the suit. Once the suit has been dismissed and appeal has been preferred, and after remanding from the appellate court, fresh notice is required. And that has not been done. Even in the entire judgment I have searched, none of the, with nowhere it has been written.
Essay number 238 of 2017, the learned counsel for the appellant has submitted that initially the suit was dismissed on account of territorial jurisdiction, and against such order of dismissal, miscellaneous appeal number 4 of 2005,
Madam, that is 4 of 2003.
4 of 2003 was filed. But thereafter, no notice was issued to the defendant number
1 and 2.
1 and 2 who are the appellants before this court, and consequently they could not file their written statement and contest the suit. He submits that on this point, substantial question of law will be framed and decided. Before framing the substantial question of law, the records of the case would be required. Let the records be copied from both the courts. बिना ऑर्डर शीट देखे नहीं करेंगे.
4 अपील का जो है अपील नंबर 4 of 2003 का ही मानो कैंडी रिकॉर्ड में
इससे आप जो है ट्रायल कोर्ट का रिकॉर्ड है वो आएगा और जो एपीलेट कोर्ट का रिकॉर्ड है वो आएगा. ट्रायल कोर्ट का रिकॉर्ड से ही पता लग जाएगा कि आपको कब नोटिस हुआ. इज देयर एनी ऑर्डर डिबारिंग यू फ्रॉम फाइलिंग रिटन स्टेटमेंट? वी डू नॉट नो.
ऑब्लेशन
10th number. 10th number.
Nielsen check for orders item 35, second appeal 193 of 2018.
Where is your IE?
Your addition, the IA number is 118689.
What is your prayer?
So the prayer is for service of notice on respondent number 1A to 1D, substituted with order dated 14/8/2023 through the executing court in execution case number is 217 of 2018, and in addition for further proceeding of the execution case number 217 of 2018.
What is the stage of the execution
In
case?
addition, it is fixed for orders on 29 of
For orders on what?
it should be on the instructions. I have been told that it is fixed for orders of the execution case.
What orders? Orders for what? You have filed it on 19th, but you have not stated so what is the stage of the execution case in your petition. What was the suit about?
Okay, so the suit was filed by the plaintiff for mandatory injunction against the defendant for construction on the scheduled property B and for status on scheduled property A.
IA number 11689 of 2025. 2025. For an appropriate order, so that the respondent number 1A to 1D be served through the executing court.
Yes.
And as much as the execution case number 2217 of 2018 arising out of title suit number 43 of 2003 is pending. Before the Court of Learned Civil Judge, Senior Division, Jamshedpur.
Your lordship, inadvertently, the execution case number is 217 and not 22. 217 of 20, inadvertently it has been.
The Learned Counsel has submitted that inadvertently the execution case number has been mentioned as 2217 of 2018 at various places in IA number 11689 of 2025, but the actual execution case number is 217 of 2018. Is permitted to make the necessary corrections in the interrogatory application during the course of the day. In reading, जहाँ जहाँ है सब correction कर दीजिए. The order dated 1/8/2024 reveals that notice issued upon respondent number 1C and 1D has not been validly seen. ये last sentence में था. Considering the aforesaid submissions, the counsel for the petitioner is directed to take steps for service of notice upon respondent number 1A to 1D through the advocate representing the aforesaid respondents before the executing court who are pursuing the execution case. The affidavit regarding service of notice through the advocate should be filed within a period of 2 weeks from today. कब है next date executive?
29.
29th.
August.
The learned counsel has also submitted that. The executing court is proceeding in the matter, and the next date in the executing court is 29/8/2025. In view of their proceed submissions, the matter is directed to be posted on (23rd of September) in the supplementary cause list. Till 23rd of September, further proceedings in the execution is listed. एग्जीक्यूशन केस नंबर फिर से लिखना पड़ेगा, बताइए एग्जीक्यूशन केस नंबर 217 of 2018. Let this order be communicated to us. आइए में एक नोटिस कर देंगे ना, मेन मेमो में भी तो जाएगा नोटिस। Notice be issued in the main memo as well as the IE. ये कब admit हुआ है केस? Admitted on
order dated 6/11/2019.
6/11/2019.
Order number 3 years.
The case was admitted for final hearing on 6/11/2019 after framing substantial question. Give your appearance. Senior का नहीं, आपका appearance चाहिए. Senior का नाम नहीं लिखना है appearance. Who's your senior?
Mr. Prashant Kallo, learned advocate.
अपना नाम लिखिए.
Yes, Your Honor.
From supplementary list for orders notified Title 3, Second Appeal 432 of 2017.
Certified copy and an IA for condonation of delay. There is further stamp reporting and short court fee is found negotiable. Have to find
This short court piece is by virtue of further stamp to
further stamp reporting.
essay number 432 of 2017. Time till 2nd of September is granted to the applicant to remove the surviving defects benefit. If the defects are removed within time, close this case under appropriate heading on 9th of September.
Item 4, First Appeal 157 of 2018.
This will be defective. Please. Appellant absent. Goes to same order.
Item 6, Second Appeal 185 of
In
2019.
fact, दोनों party are absent. Parties are absent.
Further stamp report ticket rupees 2800 rupees we have to deposit within 1 week, my lord. And so far as other defect IA has been filed, my lord. One IA, my lord, we take IA 11720.
What have you prayed in that?
Is that, my lord, one of the party in the impugned judgment and decree, my lord, Lakshmi Devi, she died just after pronouncement of the judgment in first appeal. So he was not arraigned. Her legal heirs and representative were already party in the appeal, civil appeal also, and in this second appeal also. So only prayer is for grant of leave to pursue the second appeal in absence of Lakshmi Devi. Para 1, my lord, I have prayed to ignore the defect regarding not arraying Musmat Lakshmi Devi as party in the second appeal. And the relevant, my lord, statement I have given, my lord, in paragraph 5, my lord.
And therefore she has not been made party.
Yes, yes.
इसमें कभी notice हुआ है respondent?
नहीं, कभी नहीं हुआ। लिमिटेशन में भी जाएगा तो बेटर, मैं लोग both in both the IA notice may be issued, and in the meantime I will also deposit the court fee which has been pointed out by further stamp.
पहले आप court fees जमा करें.
My lord, only 1 week.
Also for the appellant, praise for and is granted time till next Wednesday to deposit the deficit court fees. The question of issuance of notice on the interlocutory application will arise only thereafter. Next, Wednesday 20th
बात 2 दिन और है, Friday.
by Friday next.
4th.
ना हम लोग छुट्टी मना रहे हैं.
By 8th.
By 4th. By 4th हो जाएगा ना?
अब
By 4th आप कर दीजिए.
जी,
Post on 10th.
my
Orders. Item 7. Second
IA
Appeal 42 of 2022.
so that IA has been filed for continuation of delay, my lord. There is a huge delay, my lord, about 5,000 days, my lord.
Second appeal में 5,000 days का delay क्या करेंगे?
My lord, scheduled trial and my lord will find weak where But the appellant has very strong case, my lord. Scheduled tribe, illiterate person, my lord. Recently, when came to know that 144 proceeding is going on, the case is very simple, my lord. The defendant are claiming that they are cheek badai, they are scheduled tribe. But when the document shows that they are cheek, and the finding of the trial court is on the basis of खतियान that कि गलती से लिखा गया केवल cheek, so it will not become construed as that they are not scheduled. That's why this second appeal has been filed because there is a very strong case now, and it may be admitted for hearing.
कौन बाकी
Notice will go to. In IE itself, my lord, I have stated all the ground, even including the ground of appeal also, my lord.
ऐसे नंबर 42 of 2022 with आगे नंबर 4410 of 2022. This interlocutory application has been filed seeking continuation of delay of 5461 days. SAR केस का ऑर्डर चैलेंज किया?
Yes, my lord. Ex parte SCR order against the scheduled tribe. I filed by those persons who are cheek. My lord, only 3 line I will show. If my lord will find merit, then issue the
Just
test.
by the defendant.
I have the 22. I asked the client why you have not challenged this. So poor, so illiterate.
ये तो ये SAR ऑर्डर कैसे सूट में कैसे चलेगा?
That can be challenged because declaration of title was also solved for. Yes.
Title of the with the suit and for declaration
Yes.
of ex parte order passed in executive
Yes.
legislature.
Title was relief was straight for and not barred under 258, my lord. Not barred. Title of the plaintiff was claimed. Only 3 lines.
ऐसा सूट नहीं देखते हैं कि SAR केस का ऑर्डर जो है सूट
Yes, yes, it can be challenged. No, it can be, and it has been decided by this court. कि under article 258 of the Chota Nagpur Tenancy Act, if relief has been paid for declaration of title, then suit is not barred. Only 3 line I will show, my lord. Only 3. My lord, kindly take page number 36. Only 3 line, my lord. In order to, because such a huge delay, my lord, I cannot, without taking merit, I cannot, my lord, internal page 11 of trial court, running page, my lord, this is 30, internal page 11 of trial court. What the learned trial court finding, it is just a chance that in the Khatiyan, place of surname of ancestor of defendant, what cheek has been written instead of cheek barai. Trial court finding is that in Khatiyan cheek लिखा गया, गलती से लिखा गया, it will not affect the right of the person.
State क्या कर रहा है? State क्या कर रहा है? State did not file the written statement also.
No, state, very interesting, state has not taken all these grounds. And my lord, for registered by virtue of 42 registered deed of sale, my lord, can you see? In this case, the ancestor of the plaintiff, my lord, purchased by virtue of registered deed of sale of the year 1942. 1942, my lord.
ठीक है, issue करिए notice. In IA number, issue notice.
2210.
To the respond number 1 to 4. Through the concerned police station for which requisites be filed by the appellant within a period of 2 weeks from today. पुलिस स्टेशन ठीक है
हाँ
जाके ठीक से पूछ खाछ के थमा के आएगा. No notice need be issued to respond number 5 as Mr.
सचिन कुमार SC2SC1.
आपका भी नाम सचिन कुमार है, इनका नाम is representing the respond number 5. It will be open to the respond number 5 to file a counter affidavit to the interlocutory application seeking combination of relief, if said